Good morning, class. Settle down, please. Welcome to this crucial exam explainer. Today, we're diving straight into a rigorous academic dissection of the Transfer of Property Act 1882. Specifically, we'll be breaking down the reciprocal rights and liabilities of the mortgagor and the mortgagee. Now, for all my KSLU law students tuning in, I need you to pay very close attention here. I expect a strict, disciplined approach to this material. This isn't just some casual overview, okay? This is your definitive, structural blueprint to scoring maximum marks in your final examinations. So get your notebooks ready and let's begin. Question 15. Discuss rights and liabilities of mortgagor and mortgagee. Now, why am I reading this exact phrasing out loud to you? Because you absolutely must understand precisely what the examiner is asking. This is your standard long-form essay question in KSLU exams. Listen to me. You cannot simply write paragraphs of flowing text and just hope the evaluator manages to find your core points. That is a guaranteed recipe for disaster. A standard long-form essay question like this requires a foolproof structural blueprint to secure those top-tier marks. You need clear headings, you need statutory sections, and you need absolute precision. So, here is your structure. 1. Introduction. 2. Part 1. Rights of Mortgagor. 3. Part 2. Liabilities of Mortgagor. 4. Part 3. Rights of Mortgagee. 5. Part 4. Liabilities of Mortgagee. 6. Case laws and conclusion. Let's start with Section 1, Introduction. Reciprocal rights and duties under the TPA 1882. A mortgage creates reciprocal rights and duties between the mortgagor, that's the borrower, and the mortgagee, the lender. These are governed by the Transfer of Property Act 1882, primarily sections 60 to 77. Memorizing and reproducing this precise statutory framing is absolutely mandatory for your introduction. Do not paraphrase this. The word reciprocal is the key here. It shows your evaluator that you truly understand the contractual balance at play. Always explicitly state the bare act sections, 60 to 77, right in your opening paragraph. Actually, before you even write this introduction, write a highly organized index of these legal provisions at the very top of your answer script. It signals complete competence to the examiner the second they open your booklet. Moving on to Part I, Rights of Mortgagor. Number 1. Term, right of redemption under Section 60. Definition, the most important right. The mortgagor can redeem the property after repayment. Note, any clause preventing redemption equals a clause on redemption. Class, Section 60 is the absolute bedrock of the mortgagor's rights under Indian law. You must forcefully elaborate on this point in your paper. Once the principal money becomes due and the borrower tenders that money, the lender must return the property. And mark my words here, identifying a clause on redemption is heavily scrutinized by KSLU evaluators. If a contract tries to permanently prevent the borrower from getting their property back, that condition is entirely void. It is a clause. Make absolutely sure you mention the word clause to secure those marks. Let's look at the next few rights. Point 2. Right to transfer mortgaged property, Section 60A. They can transfer the equity of redemption. Point 3. Right to inspect and produce documents, Section 60B. They are entitled to examine title deeds. Point 4. Right to redeem separately, Section 61. They can redeem one of several mortgages. Listen carefully. You must not condense these points. Students constantly try to summarize them to save time, but there is a strict necessity to list these sequential bare act provisions distinctly. When the examiner sees 60A, 60B, and 61 itemized cleanly like this, it immediately proves your systematic study of the statute. Finishing up this section. Point 5. Right of accession, Section 63. The benefit of improvements made to the property. Point 6. Right to improvements, Section 63A. They can benefit from improvements made by the mortgagee. Point 7. Right to lease, Section 65A. They can grant leases under certain conditions. By meticulously writing out all 7 rights, along with their corresponding sections, you leave absolutely no room for docked marks. Hitting all 7 rights demonstrates a complete, uncompromising command of Part 1 to the examiner. Right. Let's transition to Part 2. Liabilities of Mortgagor. Point 1. Covenant to pay. Section 65. They must repay the mortgage money. Point 2. Duty to preserve property. They must not damage or waste the property. Point 3. Payment of taxes and charges. They are responsible for public charges. Point 4. Indemnity for defective title. They must compensate the mortgagee. Let me thoroughly expound on this for a second. Every single right has a corresponding duty. These 4 liabilities strictly balance the 7 rights we just covered. Think about it. If the borrower gets to keep the equity of redemption, they are duty-bound not to commit destructive waste that devalues the lender's security. Do not skip a single one of these 4 points on your exam.
Moving smoothly on to Part 3, Rights of Mortgagee. Let's look at the lender's perspective.
Point 1. Right to foreclosure or sale, Section 67. They can approach the court for foreclosure or sale. Point 2. Right to sue for mortgage money, Section 68. This applies in certain cases. Point 3. Right to possession, Section 69, and use of fructuary cases. This entirely depends on the type of mortgage. Now listen to me very carefully here, class. The distinction between foreclosure and sale under Section 67 is a prime area where students drop marks due to a simple lack of clarity. Foreclosure entirely extinguishes the borrower's right to redeem, whereas a sale recovers the debt from the proceeds. You must explicitly capitalize the word "or" in your exam script. You absolutely cannot have both simultaneously on the same property in the same decree.
Continuing with the lender's rights. Point 4. Right to rents and profits, Section 70. This is especially true in a usufructuary mortgage. Point 5. Right to accession, Section 70. Benefit of additions to the property. Point 6. Right to spend money, Section 72. For the preservation of the property. I want to give you a massive tip here. When you write down point 4, referencing usufructuary mortgages specifically shows an immense depth of legal knowledge to the evaluator. It tells them you know that in this specific type of mortgage, the lender's primary right is the possession and enjoyment of the property's yield, rather than just a standard sale.
Almost there. Part 4. Liabilities of Mortgagee.
Point 1. Duty to manage prudently, Section 76. They must act as a prudent owner. Point 2. Duty to account. They must account for the income received. Point 3. Duty not to commit waste. They cannot damage the property. Point 4. Duty to return property on redemption. They must restore possession and documents. Notice the structural elegance we're building here, class? I am explicitly linking this fourth duty, the duty to return the property, directly back to the mortgagor's right of redemption under Section 60 that we covered all the way back in Part 1. When you write this in your exam, explicitly draw that connection for the examiner. It proves you understand the full life cycle of the mortgage.
Section 5. Case laws. This is about cementing the legal framework.
Let me be incredibly clear. An answer script in a KSLU law exam without proper case citations is incomplete and will never, ever secure top-tier marks. You must memorize these specific precedents. First, Narandas Karsondas versus S.A. Kamtam explained the nature of a mortgage and the rights of the parties. This Supreme Court judgment beautifully laid out the nature of a mortgage. Write this landmark case down precisely. Bringing this up proves your foundational understanding of how Indian courts actually interpret the transfer of interest to secure a loan.
Next up, Kreglinger v. New Patagonia Mico established the principle of no clog on redemption. I must emphatically state that citing Kreglinger is absolutely mandatory when you are discussing Section 60. If you mention a clog on redemption in your Part 1 analysis, you must anchor it with Kreglinger right here in your case law section. The foundational rule is once a mortgage, always a mortgage.
Finally, Section 6, Conclusion. This is how you secure those final marks.
You must prepare a final, authoritative closing statement. Do not let your answer just trail off weakly at the end. Write this exact text. The rights and liabilities of Mortgagor and Mortgagee ensure a balance between borrower and lender, protecting ownership while securing repayment. Writing this concluding sentence verbatim is a highly strategic move. This concise summary demonstrates to the examiner a mature, holistic understanding of the Transfer of Property Act's fundamental objective, which, at the end of the day, is commercial equity.
Before we wrap up, I leave you with this final provocative academic challenge to really test your mettle. If a clog on redemption invalidates a contract, how will you identify hidden clogs in complex practical problem questions during your final exams? Think deeply about collateral advantages and penalty clauses disguised as standard commercial agreements. I urge you to apply this structural blueprint rigorously to your revision. Memorize the headings, memorize the statutory sections, and write with absolute academic discipline. Class dismissed.